𝗵𝗵𝗵𝗀𝗀𝗃, Flanagan. You're very welcome tonight. I'm going to be speaking about the early Irish native legal system. Irish people tend to be very close to their culture and history. We love our language. It's still spoken, even though it was very heavily attacked for hundreds of years. You can see it all throughout the city. Our music is listened to all over the world and danced to. And our native sports are just as popular today as they've ever been. But when you ask Irish people about the native laws that existed on this land, there's big gaps in the understanding. Part of the reason why I set up the Brehon Academy in 2013 was to bring awareness to those gaps, because I believe that the study of this native Irish law is so insightful that for us to ignore it is to ignore a very deep part of our own identity. What if I told you that it was once said of Ireland that there is no nation of people under the sun who loves equal and indifferent justice better than the Irish, nor will rest better satisfied with the execution of the law, even if it's against themselves, so that they too can have the benefit and the protection of the law when upon just cause they do desire it. And what if I told you that the man who said that was Sir John Davies, who was the Attorney General for Ireland in the year 1606 to 1619, and if you know your Irish history, you know that they were very significant and formative years in our history, just after the flight of the Earls, just after the collapse of the Gaelic order. A man who was not a friend to the native Irish and not a fan of the Brehon Law still had this very beautiful thing to say about these people. Fast forward a couple of hundred years, we're now into 1958, we have a barrister, an Irish barrister, writing an article called The Bench and Bar in Ireland. And he's speaking of the Irish irreverence for law now. And he says, this Irish irreverence for law doesn't stem from sympathy with crime or from wrongdoing in general, but from the fact that the Irish, who have a fairly long memory, know that the law in Ireland today is not Irish law. However just it may be, it was once most unjust. It does not command reverence as a native institution, but merely respect as an essential part of the machinery of government. What changed? How did we go from a people who were seen to be the ones who loved justice more than any other nation on earth to the ones who were seen to be irreverent of the law? The first book that I wrote, or read, should I say, about Brehon law was by Lawrence Ginnell, called The Brehon Laws, a Legal Handbook. It's not the most intellectually rigorous book on this topic, but it is a great introduction. It's very romantic. He's talking about it from this sense of something that has been lost. And he says that the laws of a land are an irrebuttable witness to the character of those people. And so what I want to do in this discussion is frame the rest of the conversation around the conflict of two legal systems. And these two legal systems represent the conflict of two mindsets. Okay? So why are we calling it medieval anarchy? How does that fit into this discussion? Were the Irish anarchists in the Greek sense? Did they aspire to this as a philosophy? No, they did not. They didn't. They were not anarchists as a value. They had plenty of rules. That's how I'm able to sit here and talk to you about them. They had loads of laws, and they had plenty of kings. They had more kings than you needed, okay? Well over 100, and they were often competing with each other. But what I want to focus in on here is a very different mindset about what is power, what is authority, and how is it administered throughout society. To the early Irish, the idea of having a centralized control, a monarch who had the right to issue laws, was an alien concept. So this is where I sit with the anarchic approach to medieval Irish law. It was on how did they view authority. The point is there was no inherent right to rule. Nobody had the divine right to rule because their daddy was the king or something like this, right? This is a very different thing. And I would argue that this is partly where the main conflict between the two systems actually came from. It wasn't a religious conflict. For 300 years, the Protestant church didn't exist, right? So we have to say, well, why were these two people who were neighbors to each other, right? A lot of things in common, but this fundamental level that they couldn't connect. So there's a couple of ways I want to focus in on how this was anarchic and to show the difference and why it was so incompatible with the colonial systems, the continental monarchies and so on, which is characterized by centralized control and a divine right to rule. So the areas that I'd like to focus on are the nature of lawmaking, the attitude to where law comes from, how do we deal with crime when there is a wrongdoing in society, And probably the most important, and I hope I have time to go a little deeper into this, is the attitude to land and property and ownership. Okay? So first, with lawmaking. Under the Brehon Law, it was a law of custom well established, not by the law of decree. How does a custom become well established? Well, when people engage in honourable behaviour with each other over time, certain practices will arise. These practices then eventually become expectations. The expectation, when it's seen to be good over time, can acquire the force of a law. How? What is the right amount of time? Well, they had it since time immemorial. They had all these beautiful ways of talking about the law. Since time immemorial. But what is that? It's only 90 years. It's like 3 generations. Once the 3rd generation had been born and that custom had been in place since time immemorial. And if it was held to be a good custom, then it would be observed by this group of people, by the Brehons. It would be recorded, they would speak about it, and it would become customary law. So in this sense, you see the Brehon system with its polycentric nature allowed for experimentation in customs, allowed for different variances on how to do things in different communities. Now, as someone who studied law, I know the modern jurist is going to be screaming that that's uncertain. How can I be a lawyer if it's going to be different laws in different places? And that's fine. The Brehons were well aware of this. There was a difference between the 𝗺das, which was the local custom, and the 𝗺ine law, which was the universal law of the land, which I'm sure I don't even have to tell you what that law was. Don't cause harm, don't cause loss, don't cause injury. In that sense, we all agreed what the laws were. But when it came to the actual engagement in different transactions, maybe marriage agreements and so on, that allowed for variance. If we compare this with our counterpart, we have a group of men. If we're lucky, it's a group, and if we're unlucky, it's just one guy who happened to be born to a certain bloodline, to a certain family, who is perceived to be divinely inspired by God to sit down and write laws and put them on the people. How absurd is that when you actually put it on paper? It's absurd, and this is the system that we have inherited and just take for granted and say, that's the best way it can be, it's the only way it can be. One of the things the Brehons had to do, which I really loved, was they had to articulate their judgment based on 2 things, a principle observable in nature and through a form of poetry. And there's plenty of examples I can give of this, but I'm limited for time, but one I would draw your attention to, the first copyright case, as they call it, between St. Finian and 𝗁𝗏𝗀. They had an argument over who owned the manuscript. 2 monks, okay, they went to court, and the Brehon, in his wisdom, he looked out and he found a principle in nature that a cow gives birth to a calf. So to every cow its calf. You've probably heard that phrase. Most Irish people are familiar with that phrase, but not necessarily where it comes from. It comes from the Brehon Law. Now the problem was, as beautiful as that judgment was, it couldn't stop these 2 sides from having a war, okay? So I'm not ignorant to the fact that there were some issues with the Brehon Law, especially in terms of enforcement. There was no enforcement. There was nobody there who was enacting the will of the judge or the king. There was no cops, guards, to enforce this. So you have to say, how was it self-executing? Why would people follow law that wasn't forced upon them? So making this distinction between the kind of fiat legal system, which I'm saying is the centralized system, a system of control and centralized decree, versus this more kind of holistic system, where the judgment was more important than the person giving the judgment. The title given to you by the crown of the King's Court bench or whatever was not as relevant as the person who could really find the true judgment. I'll try and give you a very quick story. There's a longer version on my YouTube channel if you want to look at it. It's the story of how King Cormac was recognized. Very short version. There was a woman who had a sheep. The sheep escaped, gets into the crops of the queen, eats the crops. There's been a loss, an obvious loss. It's quantifiable. You can see that there's been a loss, damage has been incurred. She asks her husband to be the judge, which was completely acceptable because the king was expected to have the judgment of a Brehon, or we might say the judgment of King Solomon. It was seen to be a kingly trait to be a good judge. And he said, well, this is obvious. There's a loss of the crops. This woman has a sheep. She should give the sheep as payment for the crops. Makes sense, right? We can all see there's an accountancy has happened there. Maybe there's some restitution has happened. But a young boy hearing this in the crowd said, this is a false judgment. This is not the true judgment. As the fleece grows on the sheep, so does the fleece grow on the land. So surely he should give the fleece of the sheep as payment to restore the crops. Don't deprive the woman of her livelihood. I can see you smiling because you can feel the difference in that, right? Am I right? You can see the difference. Am I getting nods? And did it feel something? That feeling, that's why the Irish love justice better than anybody else. It was something that you could feel, something you could experience. That's what their belief was. It was very tied into who they were as a people, their identity, the honor that you have in society, and the fact that the laws are the irrebuttable witness to the character of the people. So, moving on to how do they deal with crime? Okay, there's been a wrongdoing. First, our system, if you haven't studied law, this isn't always obvious. A crime is not when there's a victim, a person. A crime is a crime against society as a whole. Civil law is when it's two individuals, but in criminal law, the state steps in as the prosecutor and the victim and the injured party in the form of a DPP or something. We take this as normal. Can you not see how absurd it is that a third party might step in and say, oh, I'm going to take the offense on behalf of that victim? It is absurd, and it was absurd to the early Irish. There was no way that a third party could step in and claim compensation. Okay, there's a story there with 𝗲𝗏, and it did come in through the church, but that's a little bit more technical than I want to get into. How did they define a crime in Brehon law? Very simple. It was a lapse in the standards of personal honor and brotherly kindness. A lapse in the standards of personal honor and brotherly kindness. That was your crime. And then the degree of malice and so on was taken into account, like as Dr. Friedman was saying, it's very similar to how they dealt with wrongdoing in Iceland. But the point was that they were trying to resolve the issue. They were trying to find a harmonious rebalancing in the society. And that might sound kind of hippy-dippy and 70s stuff, but what's the alternative? You have an adversarial system right now where families are broken in those courts and never to speak again because it's not made to be amicable. It's not made to resolve the real healing that needs to be done within the family. The Brehons were willing to do the difficult calculations that we don't tend to do so much today. And what I mean by that is they took account of so many things, such as the honor price of the individual, the circumstances that led them to that place. Usually the Brehon would be somebody who would have some awareness or knowledge of the people involved, so they're not completely strangers to each other. I liken this to Richard Posner's much more recent economic analysis of law from the Chicago School. And he was like making these kind of discoveries that all law is economic and all crimes can be based on economics, which is what the Brehons were doing thousands of years beforehand. I was going to tell you the story of Setanta and Cuchulainn and how he got his name, but I'm sure most people probably know that story. I want to give you a story that emphasizes the restitution, the spirit of restitution in Ireland. With Setanta, he killed a dog in self-defense and immediately said, I'm going to be your dog, and he replaced the dog. But there's a better story I'll tell you about the story of Partholón and his wife. So Partholón was one of the early groups of people to come to Ireland. He led them. This is before the 𝗃 the Danann. We're in mythology, probably didn't exist, but it's in our mythology and has been influential throughout these years. One day Partholón goes out to hunt. He leaves his wife alone at home, and she succumbs to some temptation and decides to bed one of their servants. Now, if that wasn't a big enough insult, they drink from his very special cup. He had a sippy cup, and they drank from that cup. And when he came home and drank from the cup, he knew that the betrayal had happened. And in a fit of rage, what did he do? He killed, not the servant, the dog. He killed the dog. I mean, that's the part where I just stopped liking Partholón, when he killed the dog. The dog's name was 𝗁𝗵𝗆. So what happens next? You think this is pre-Christian, thousands of years ago. The woman belongs to the husband, right? He could do what he wants. No, the woman, the wife, summons the king, her husband, to the court. And the judgment is described as a very noble judgment, that it is the right of the wife to recover against the husband. Now, today that's whatever. Back then, this was unthinkable. It was phenomenal how forward-thinking they were in terms of women's rights, property, and their ownership within the marriage. As compensation, he had to restore the loss. He had to give her an island. And to this day, that island is still called 𝗃 after the dog, and it's up in Donegal. So I was telling you this story to show you, 5 minutes? Perfect. to show you just some of the, to try and give you some of that insight into what was the character of these people who produced this law that is reflective of their ambitions, their aspirations, and the type of society they wanted to have. I'm not looking at it with rose-colored glasses. I could sit here for an hour and tell you all the problems that were in it, but what I'm trying to do is trying to help us, Irish people, to feel a little bit more of what we lost here, and that there is a lot of value in looking back to the wisdom of our ancestors to try and find at least guidance into the future. I'm not saying we should go back to trading in cattle and stuff, but there's definitely points in here that can give us answers that are not obvious to us in our modern society. So the last thing I want to focus on is the attitude to land and ownership and property. And this is, I think, one of probably the most fundamental parts of the clash of these two legal systems. In the British and continental system, you have primogeniture, which means that the firstborn, usually a male of the family, is the one who inherits everything. In Ireland, we had a system called tanistry, which is where we get the name of our Taoiseach today, right? We call it the Taoiseach from this old custom. And the Taoiseach is basically the second in command. And they would have been elected through the election process during the lifetime of the king. Why? Well, they wanted to avoid disputes in the event of a succession. If you don't have a clear heir, then you have these competing families and they all want their son to be the one. So to avoid the disputes, they would have an agreement beforehand that this is going to be my second in command. This is really important. Title is something that passes down. Title is property. And the English administration could not be successful is so long as the title of the land or chieftain would pass to somebody who wasn't continuous. That broken chain where, let's say you're the chieftain of the tribe and I'm the crown, I make a contract with you. The mindset of our people would be like, great, you made a contract with the crown, good for you. How would that bind me? How would that bind the rest of us in our tribe? And this was a problem for the British because they couldn't make one contract with one person and say we now own all. It had to be slowly over time. Two ways to emphasize this. Before I mention that, I would say this is important as well. The Irish knew deep down in their heart that you could never own land. It was something innate in the culture. You could use it for a time being, and then you would go back into the land from when you came from, okay? So this is a very different kind of mindset than what we've inherited, which is the land is to be colonized and taken and take as much of it as possible and put your flag in. We heard in the Icelandic example, monopolies formed as people started to claim ownership of land. Whereas in the contrary system, it was all about how much land you owned and taking it off people. Example of this, first one, surrender and re-grant. You probably remember from history school, the surrender and re-grant. What was that? Basically, the crown said, just surrender to us your British, your Irish titles. Don't be chieftain anymore. Don't do tanistry. Give us all your lands, and we're going to give it right back to you with a new title. And the title was Earl or something like that. That's a very significant part of our history, and I wish I had more time to go deeper into that, maybe in the questions. Second example is the case of tanistry, which is probably the nail in the coffin of the Gaelic order. It happened in 1608, so right after the flight of the Earls. You had a land dispute between two different factions. One of them was claiming primogeniture through the English system, and the other one was claiming, through the Irish custom that had been present for thousands of years, succession through tanistry. The courts declared that this custom is repugnant to English law, and that's probably the exact right word, that's the only word that they could have used. What they mean by that is these customs are incompatible with our law. We need people to be in possession. The law abhors property in a vacuum. So there's more that I'd love to go into, but time is tight. Trying to squeeze several thousands of years into 20 minutes is a challenge. I guess I'll just wrap up by saying I have a lot of videos online. I have online courses and so on. If you want to learn more about this, I'd invite you to do that. And just to say thank you to all of you guys for coming out this evening. We didn't know, we thought it might be an empty room. Thanks to John for organising it and Students for Liberty. And a huge 𝗁𝗵𝗶𝘀 to David Friedman for the opportunity to share the stage with him. Thank you.